So good morning, everyone. My name is Ana Paula Martinez. I'm a partner with Levy Salomão here in São Paulo. It's my pleasure to welcome you all to our event. I'm here with my friends, Mike and Lee from Steptoe, and my partners who are also my friends, Mariana and Marcos. Before we start, just some things that I would like to share with you. So first of all, this session will give you CLE credits, and we will be giving 2 CLE code words throughout the session, so bear with us. And today our purpose is to discuss recent developments on merger enforcement, both here in Brazil and in the US. We're gonna be discussing hot topics such as ESG, labor considerations, merger review procedures in general, and digital markets. Before we start, I will quickly introduce our speakers today. We have a house full of Georgetown alumni. Mike, Lee, and Mariana, they all went to Georgetown. Mike is based in New York, and he has an extensive and impressive track record in merger cases and litigation cases. Lee is associated both with the DC and San Francisco offices of Steptoe. He was the first chief of the Civil Conduct Task Force with the Antitrust Division of the DOJ. Mariana used to be in government, so she served with the federal government for 9 years. She headed the then chief investigative antitrust agency in Brasilia, which was also in charge of antitrust matters. In that capacity, she was my boss, and I guess the relationship went well, and she decided to move to private practice with me back in 2011. And Marcos Malvarte he's based in Brasilia. He also has a very solid academic background, and he gets to see many things that we don't see in São Paulo and that he sees every day in Brasilia. So without further delay, I will start our discussions. This panel is will last for 1 hour and a half, and punctuality is one of our core principles, so we'll make sure that we'll remain in time. So we're gonna jump into our first question. And Mariana, I would like to hear from you on merger enforcement priorities. We know that this changes over time, and we can see across, I would say, the last 20 years, some changes in the policies here in Brazil. What are your views on that?
Thank you, Ana. Good morning, everyone. Well, let me begin by apologizing for my voice. The Brazilian audience may recall this very famous TV ad from the 70s where this lady for this Brazilian shampoo brand, where this lady with great hair appeared on screen saying, "Do you remember my voice? It's still the same, but look how different my hair is." Unfortunately, for the purposes of our session today, I'm in exactly the opposite situation. Clearly, my voice is not the same, but I don't think there's anything particularly different with my hair. But please stay with us. I promise that what we'll cover today will make up for my terrible voice. But to your question, Anna, and the timing for this discussion is really so perfect. As many of you will know, yesterday our Senate confirmed the 4 new members to serve a 4-year term at CAGE's tribunal. 3 of them are prominent lawyers, and 1 of them is a prominent economist, and all are very respected in their field of expertise. At least 2 of them have a strong antitrust background and have worked at the agency. And the general expectation, certainly mine, is that this will lead to a more nuanced and rigorous approach to antitrust policy and enforcement. I know the topic today, our topic is today, to which you referred, is merger enforcement, but just very broad strokes on the main enforcement areas. Cartel enforcement for domestic and multi-jurisdictional reasons that are outside the scope of our discussion today. Enforcement has seen stronger and more consistent days in the past. On unilateral conduct investigation, truth be told, the focus shift and it became an enforcement priority relatively recent. We have seen some action in this area last year. The general superintendent established a dedicated unit to investigate these cases, and there is an apparent increase in the number of investigations. But the fact is that there are very few final rulings, and even more importantly, there are actually very few precedents that provide useful guidance on what CAGI believes is relevant with respect to dominance, to abusive conduct. On merger review, and now answering your question, I also think it's fair to say that enforcement has been stronger. But in my view, the key issue here is unpredictability. On the one hand, there have been relatively few cases with behavioral structural remedies during the past 5 years. 6 per year, except for 2020, where there were 7 cases, and in 2018, where there were 5. This year, CAGI blocked 1 domestic transaction in the health insurance sector because of significant overlaps in the northeast region in Brazil, particularly in 2 states. And the last transaction blocked by CAGI before that had been in 2018 in the LPG market. But on the other hand, there are decisions that are extremely difficult to explain. And one can only sympathize with counsel involved in these cases because, frankly, no one would have seen it coming. I'll mention one. In this particular case, CAGI imposed remedies to a multi-jurisdictional JV that was established to enhance sustainability in the automotive industry. This transaction was filed and cleared by 6 other agencies and that reviewed the case, and by the general superintendents at CAGI, which was, and the decision was so unexpected that it ultimately resulted in Brazil being excluded from the collaboration, and therefore Brazilian consumers arguably not benefiting from such efforts. Gun jumping is still a priority. The number of cases has also decreased over time, but with respect to that, I can see other possible explanations for the numbers. One of which is we might have reached a point where we have successfully transitioned from a post-merger review system into a pre-merger review system. I'm not sure that explains all of it, but it's certainly one possible explanation. And finally, and I'll pause after that, CAGI is very focused on international cooperation. If we have time, we'll go back to that, back to this point. But for our international audience in particular, one key aspect to be aware is that in all high-profile and or transactions that involve some degree of complexity, one of the first things that we should expect to hear from CAGI is, I would like to have a waiver, please. CAGI pays significant attention to what jurisdictions like the US and the European Commission are doing, plan to do with the case, and is also very often sought by counterparts in Chile and Mexico and in Colombia to discuss these cases as well. I'll pause for now.
Thank you, Mariana. And Lee, what about enforcement priorities in the US? How do you compare to Brazil, and how active the US has been in recent years?
Thanks. So Mariana said that the hallmark of CAGI has been unpredictability. I would have said maybe that would have applied to the last administration here in the United States. This administration, I think the philosophy is one that my father had when I was a little kid, which was, if you have to ask, the answer is no. So in 2021, the new administration came in and had a very substantial shift in the outlook for merger enforcement and antitrust enforcement in general. That shift was both progressive and aggressive. It was progressive in the sense that antitrust was taken out of just the strict consumer welfare standard, just the standard that we should be looking at all antitrust matters as to how they will affect consumers, especially prices and quality, and to think about all kinds of other ways that antitrust can be used to achieve certain policy goals. It's aggressive in the sense that the DOJ and the FTC believe that they should sue in almost any circumstance, that they should challenge almost every merger that's coming their way where they think they have any shot of prevailing. And I'll go into that in a little bit more detail. But first, as far as priorities go, definitely the biggest priority are the big tech companies. And this comes out both in merger cases and conduct cases. And I know we'll be talking about that a little bit later in this presentation. Other priorities are the big agricultural companies. We've seen that in some merger enforcement. There's a significant merger enforcement action in the chicken industry last year, but we've also seen that in the conduct space, in both criminal and civil conduct enforcement. And also there's been a concentration in theory on private equity cases. I say in theory because there haven't actually been that many merger enforcements in private equity cases as compared to the amount of talking that that Jonathan Cantor, the Assistant Attorney General for the DOJ, and Lena Khan, the chair of the Federal Trade Commission, have done in attacking private equity. There's also a focus on labor. The focus on labor is both in merger enforcement and in conduct. I know we'll talk about merger enforcement with labor later. Just briefly on conduct, there's been a focus on no-poach cases, on non-compete agreements, on wage fixing and information sharing in the wage of wages and compensation between companies. Now, getting to the aggressive approach, the investigation philosophy of this administration is first, the administration is willing to litigate everything. So there's always the threat that we will litigate, and that they don't want to settle anything. They, in fact, have a policy in place that they will not settle merger investigations. That instead, if you come in with a potential issue, you go through an investigation. In the old days, you could say, okay, now that we've identified what this issue is, we will divest the asset that you're concerned about, and then you'd enter a consent decree. That path is closed now. If you come in and you go through the investigation and you identify the problem, and you say, okay, we're willing to divest, the DOJ or the FTC will say, doesn't matter, you should have fixed that first, we're going to sue you. And they've not had a great track record on that position. The one case that the Asa Abloy case where they had pushed that position, they had ended up getting in front of a judge that said, I don't understand, it seems like you guys can settle this case, why aren't you settling it, and force them into mediation, and ultimately the DOJ did have to accept that. And then I think that there is a willingness in this administration to make the point, even if they can't win. So they will bring cases that other administrations would not have brought because they don't feel like they have the evidence or the law on their side, but they believe in the underlying reason for the case. And therefore, even if they think it's likely they're going to lose, they're still going to bring the case. And I think that's driven by this overall feeling in this administration that if the antitrust enforcers don't step in to solve what they perceive as a problem, then no one else will. And that philosophy drives the much larger number of litigations that we have seen in the last 2 years as compared to prior administrations.
That's very interesting to hear, Lee. And in fact, I think it's a different system than in Brazil. Of course, we both have pre-merger review systems. But nonetheless, I don't think it will work in Brazil if CADE decides to take everything to courts just because of how the system works here in Brazil. We were under a different system, but just to give you an example, under our old post-review system, there was this very landmark case involving two chocolate makers, Nestle and Garoto. So the CADE decided to block the transaction in 2004. And just this year, after almost 20 years of litigation, we had a final decision and the merger went forward. So all this to say that it was a different system. I think we will be under different rules of incentives and so on and so forth now. But nonetheless, I think CADE will always be more prone to settle. The alternative will be to block the transaction. but then I think it will be inefficient from a consumer welfare perspective. But now moving on to my second question, and going back to one of your issues that you raised, one of the priorities, which is digital markets. And I will ask Mariana if there has been, I know that worldwide there has been a lot of scrutiny in digital markets, big techs, a lot of cases against Google and Amazon and so on and so forth. Is Brazil active in that front? Are there regulatory actions or landmark cases that stand out?
Thank you, Anna, but I just won't resist reacting to your comments on Lee's point. So we have to thank our court system for having a deterrent effect on the copycat effect that CADE could be tempted to follow looking at the US. I totally agree. But on digital, it's interesting. CADE has listed over the past years enforcement in the digital markets as a priority, and some of its key outreach initiatives do include, for example, a comprehensive study on digital platforms market. They issued the first edition. They updated it in August this year. But if you look below the surface, I would say that we're not yet at a point where we can say more than that CADE is paying close attention to what is happening in digital. For one, we hear public statements from key officials that are difficult to reconcile. CADE's president has stated more than once that antitrust is no panacea, that their job is to carry out traditional antitrust analysis, that he considers consumer welfare standards as the appropriate standard of review. And I've heard from US practitioners that sounds refreshing, and I agree with that. On the other hand, we've heard some commissioners now. I'll mention an interview by a recent interview by Commissioner Vitor Fernandes, that where he expressed concerns regarding high market power of digital platforms, and that traditional antitrust rules might not be appropriate, might not be sufficient to address unique challenges of digital markets. But more than that, I think that's a key aspect, that we don't know what the agency really believes with respect to the applicable rules and what's the standard of review with respect to digital. But more importantly, when you look at the investigations, that's also quite unclear. CADE has launched a number of investigations on abuses of market power by digital platforms, but so far we've seen very limited enforcement, and most cases are closed for lack of evidence of any competitive behavior. But my point here is that regardless of the conclusion, if you look below the surface, it's difficult to know what CADE considers relevant or not to reach a finding of market power and of its abuses. That's where I clearly think it's room for improvement. There's room for improvement. Further clarity on with respect to digital, where there might be a problem, where there might not be a problem. I'll mention very briefly a few cases. CADE opened an investigation, for example, against Google. I'm sorry, again, I'll go back to Google in a minute, but against Apple, following a complaint by Mercado Livre. Mercado Livre is the lead e-commerce platform in Latin America. They complained basically about Apple's app store, its policies. They're allegedly anti-competitive and restrict competition in the mobile app market. These policies allegedly force developers to use Apple's payment processing system, which would allow Apple a 30% commission on all sales, and bans developers from directing users to other payment methods outside the App Store. That's one case. There's other case where Facebook, where CADE is investigating Facebook and Google because of for allegedly carving out the part of the online advertising market. CAGI opened this investigation ex officio based on news of an investigation in the United States, again, copycat, and the European Commission on the JDI Blue transaction. This investigation was initiated as a preliminary procedure. The first step of the investigation now is already an administrative inquiry, and CAGI is carrying out market tests, issuing RFIs to other players in the market to understand the practice, the conduct, and its effects. There was also an investigation against Google and Meta following a complaint by Congress regarding an alleged abuse of dominant position in a campaign against the draft bill that is pending approval in Congress. CAGI had to open this investigation because it came from Congress. It's unclear whether there's any substance on antitrust substance on that, but it is an investigation targeting big tech. CAGI is also looking at some cases against Google, and some of the previous cases against Google, also following conduct was investigated abroad, were closed for lack of evidence of an uncompetitive behavior. But now on the merger front, where there are two noteworthy developments. The first, to which I referred briefly before, is the fact that as of today, leaving all the noise aside, merger review carried out by CAGI in digital markets strictly reflects what is set forth in the horizontal merger guidelines. There are no specific or additional angles in these analyses. And that's good and bad. I mean, I would agree with the conclusion, but I'm not sure that it's helpful if we have to advise clients what's CAGI looking at. It will be challenging to say. CAGI consistently cites two precedents when it looks at digital cases. One is Stone Links, and the other one is Magalu and PayHub. In these two cases, the competitive assessment was carried out exactly like that, in a traditional standard fashion. The other development that I'll mention is that this year, the general superintendents enforced its clawback provision. It's a provision in our law that allows CAGI to request to review cases that fall outside the mandatory finding thresholds, 1 year, up to 1 year after closing. And it used this provision to investigate a case in the digital market for the first time. In October, CAGI decided to request that Travel Research and Purchase, that the two platforms on travel research and tickets purchase, Max Milhas and 123 Milhas, should file their transaction for review. This case is interesting because CAGI read the news and they were saying all these great things about how big they were, how much money they were making, and CAGI, well, this is big, I need to have a look at it. So they were CAGI requested to the review. The sad part of this story is that they went bankrupt, but not because of CAGI, but this is the first case, and what's noteworthy about this, that it's indeed the first case where CAGI used its clawback provision to request to review this case. And this follows a trend in other jurisdictions, and leaving aside this sad case, I think it's something to look out for, even though these cases, because of their turnover, might not be reportable to CAGI. If we're advising clients in similar deals, it might be worth including provisions in the contract that say that align the expectations that this might still be reviewed by CAGI post-merger, post-closing. Thank you.
And Mike, what's the situation in the US? I know that there's been big cases like DOJ against Google, and the most recent case, FTC against Amazon. What are the takeaways for our audience?
So the takeaway is lots of litigation. That's the quick answer. And let me take this opportunity to give you the first code word for CLE purposes. If you want to have a CLE credit, the first code word is litigation. The code word is litigation. So So Mariana talked about the investigations that are going on in Brazil. In the US, there are lots of investigations and there's lots of litigation. This slide shows you a scorecard of some of the litigations that are going on or have gone on. And in the US, in addition to litigations brought by the US Department of Justice Antitrust Division and the Federal Trade Commission, we also have the state attorneys general active in bringing lawsuits against big tech companies. And also in the US, private litigation is very significant and very important. Mariana mentioned the investigation of Apple for monopolizing the distribution of apps on the Apple Store. Let me first talk about briefly a litigation that reached a jury verdict yesterday that's actually not on this list. It's a private action brought by Epic Games against Google, in which after a multi-week trial, the jury took 3 or 4 hours to decide that Google had in fact monopolized the distribution of apps on the Android platform. The case is seeking injunctive relief. The hearing is not set until almost a year from now, next November, to talk about remedies, but that's going to be a very significant decision. So lots of litigation. I can't within 5 minutes tell you about all of these cases, and in fact, you can read most of them on the front page of the Wall Street Journal or wherever else you get your news. But let me talk a little bit about the one of the Department of Justice cases against Google, and that's the search and search advertising case that had a 2-month trial. It started September 12th. It wrapped up on November 16th. There'll be closing arguments in the beginning of May. The judge left the parties with, very good presentations by both sides. I have no idea what I'm going to do. But there are, I think, 2 key issues in the litigation. The first is market definition, and the second is anti-competitive effects. With regard to market definition, the Department of Justice alleged that Google has a 90% share of a market for general search and 95% of general searches on mobile devices. And Google's response was, no, we compete not only with Bing and DuckDuckGo, or DuckDuckGo to be more precise. So don't look just at general search, but in fact, we're competing with social media in general and other vertical search engines. We're competing with Amazon and TikTok and Expedia and TripAdvisors and Yelp and Apple. They're all competitors. And customers are using search bars on TikTok, using search bars on Instagram. So you're looking at an artificially narrow market, United States. And the DOJ response to that is, no, search ads are different than banner ads or display ads. Specialized vertical providers, like you're talking about, are different. Amazon only allows for searches for products, whereas on Google, you can search for services, you can search for all sorts of things. You can't book travel on Google. You need to go to a specialized site for that. No, general search is just different. And Google's response to that is, now, well, advertisers are looking for the best return on their search on their advertising dollar. They switch the type of ads that they buy in order to get better results. So general search ads are competing with lots of different types of advertising. And DOJ's response to that, it was, well, no. Look at what we're talking about here. We're talking about your exclusive default positions, Google, and your exclusive default position doesn't prevent anyone from pre-installing Amazon or TikTok or Facebook. You're just preventing people from pre-installing other general search engines. So obviously you must think something is different. And you have a tool that you provide to advertisers, which you call Performance Max. That's an advertising optimizer tool. And that one treats search ads as being different than display ads. So that's sort of the back and forth. That's my 2-minute summary of a 2-month trial. My own take on this, my fearless forecast, I sort of think general search is different. And I think DOJ is likely to be persuasive to the judge on that. The second issue, are these exclusive default positions having an anti-competitive effect? DOJ alleges that, yes, they lock out the competition. And Google's response to that is, no, we competed for those slots. We beat them in the marketplace. We're competing to get these slots. And besides, it's not the default position that makes a difference. We have our high market share because we're better than the competition. And customers agree. Yahoo, in a number of years ago, outbid Google by $100 million for the default position on Mozilla. And guess what? Customers hated it and required Mozilla to move back to Google. an expert witness who testified that only 2.9% of the quality gap between Google and Bing can be explained by relative size. And DOJ's response to that is no, having the default position is very important. DOJ's expert talked about a strong user bias for the default position, the status quo bias, I guess is what they called it. Google's response to that was no, the default position it's important for us because we want to have a consistent position across platforms. And our expert, Google's expert Kevin Murphy, testified that even if you had a choice screen, only about 1% of US consumers would switch away from Google. DOJ's response to that was when the EU ordered Google to put in a default screen, Bing and Bing and Yahoo and DuckDuckGo all increased. Google's response, yeah, competition is still just a click away. You can still compete for consumers even if you have the default position. DOJ's response was, no, it's not a click, it's multiple clicks on multiple devices, and it's complicated. Sometimes it's up to 13 steps, and it does matter. Scale is important, DOJ says. Size does matter. Google says there are diminishing returns to size. DOJ says, well, they may be diminishing, but they're not vanishing. They're still important, and the exclusivity locks out the competition. If the default position were not so important, Google, then why are you paying $17 billion a year to Apple and $26 billion a year in general for the default position? And Google's response was, no, well, these payments are not an attempt to maintain a monopoly. It's because we view Apple as a competitive threat. To which DOJ says, well, you can't pay your competitor to stay out of the marketplace. So, I mean, again, I'll give you my fearless forecast. I still am struck by the stubborn fact, gee, why do you pay $17 billion a year for a default position if default isn't important? Again, I think DOJ has the better part of the argument here, but we'll see. And even if that happens, the real action in this case is going to be the remedy phase, and the remedy phase is not going to start until the spring at the earliest, more likely later in 2024. So lots of big tech litigation. It is an enforcement priority, and there's all sorts of action going on.
Thank you so much, Mike. As Mariana said, we're getting some of those cases here as well. I will now turn into another hot topic, ESG. And Lee, I'd like to start with you. And global trend is also refers to the integration of sustainability considerations into merger review enforcement. I think it's fair to say that the European Commission took the lead in this subject some years ago. What is your view of how things are being dealt in the US? Are there key cases that you would like to share with us?
Absolutely. So the United States is at an interesting political point on ESG issues. Not just the political left, but big business has generally been moving in the direction of implementing ESG policies. But they're running straight into a political movement on the right, known as the anti-woke movement, where politicians are taking stands against ESG policies as a way for allegedly liberals to push their liberal agenda onto consumers that don't want it. And these political pressures are manifesting in a number of ways. So perhaps most interestingly and most inconsistent with what I had said earlier today about how the agencies are being progressive and aggressive, on ESG, the agencies have taken a firm position that they don't consider ESG. You can see in the pullout quote on the slide here, 2 quotes from Lena Khan, the chair of the FTC, essentially saying that our job is to look at antitrust issues. Our job isn't to consider ESG. I think the main fear that they have is that companies are going to use ESG as an excuse for anti-competitive behavior. And so there is no policy from either the DOJ or the FTC about ESG, when ESG might be lawful or a lawful excuse for otherwise anti-competitive behavior. Instead, from the agency standpoint, ESG is irrelevant. We don't care why you are doing what you're doing. The real question is, what is the effect of your actions? But those anti-ESG forces, the anti-woke forces, have been very active in using antitrust laws to attack instances where companies are working together to achieve ESG goals. They've been investigating especially environmental policies and pledges that companies have made to UN organizations, to trade associations as being, quote, climate cartels. And this is not just rhetoric, though there is a lot of rhetoric around it. There is a coalition of state attorneys general, 21 currently, who are investigating companies for making these kinds of climate pledges. Perhaps their most effective investigation so far has been into the Net Zero Insurance Alliance, which is an organization supported by the United Nations that has a target goal of decarbonization by 2050. And all of these insurers and reinsurers had made pledges that they would, in both their own business, but also in the assets they manage, reach that decarbonization goal. And the state AGs have investigated this under antitrust laws, saying that, well, by making these parallel pledges, you are all agreeing to a policy, and that agreement is unlawful. I would say my view is that so far those attorneys general have not really stated an antitrust claim. They haven't showed what an anti-competitive effect is to these agreements. They haven't shown that they're anything that would be in the U.S. per se, like a price fixing case or some other kind of per se coordination, but also that there's just not any kind of effect to it. But it doesn't matter. The effect has been real, that the majority of the members, the Net Zero Insurance Alliance, citing antitrust risk, have now pulled out of the alliance and withdrawn their pledges. In the US, the House of Representatives Judiciary Committee has also been focusing on ESG, has issued subpoenas to asset managers and shareholder advocates, alleging that they are adopting and opposing left-wing environmental, social, and governance-related goals. Same kind of theory, that these companies are making pledges and working together to impose these ESG theories. So what are the risks, real risks here? I think the companies should be careful about making pledges and commitments. We have not been advising our clients not to make pledges and commitments, but to do so with the understanding that there are state attorneys general, and perhaps that there's a new administration, federal investigators who have an interest in looking into these issues. So if you're going to make a pledge or commitment regarding ESG, you need to make sure that what you're doing does not have an anti-competitive effect. And also be very careful when you're sharing information about your ESG practices or your best practices, because it can be very easy to cross from talking about your ESG practices in general into other issues that might be more competitively sensitive.
Thank you, Lee. And Marcos, what about Brazil? Mariana has already mentioned the Catina X case, which we had a very different outcome compared to other jurisdictions. And I know there is also another landmark case in the agricultural supply chain. So can you comment on those cases and others that you think are relevant?
Definitely, Anna, and it's a pleasure to be here with all your friends. And I don't think that Kaji, having heard what Lee just told us about how things are going in the US, I don't think that Kaji or Brazilian authorities in general take a different instance, although they are less vocal on this anti-woke movement. They recognize and acknowledge that Brazil is at the forefront of the sustainability discussions. It's the largest Amazon country, so it's a very sensitive issue here in Brazil. But from an antitrust perspective, the main concern of the antitrust authority has been not to allow sustainability sustainability to be used as an excuse to carry out anti-competitive behavior. So, as you mentioned, there are two landmark cases that have been reviewed so far. And in both of them, CADE did not make it clear that they are not open to tolerate further interaction between competitors than they would normally admit for other purposes, just because the goal has a relation to sustainability. In other words, sustainability alone would not be seen as an efficiency that would justify any kind of interaction that could harm competition. So in these two cases, the first one, the second one, which is the one you mentioned on the agricultural sector, which involve large traders that trade agricultural commodities worldwide, CADE has cleared the transaction without restrictions formally, but actually it took commitments that the parties voluntarily made throughout the review as being intrinsic to the transaction. In other words, if the parties do not abide to their commitments in the future, CADE will see this as an execution of the transaction differently from what is submitted to CADE, and this would amount not only to potential gun jumping infractions or a violation of the decision that CADE held, but could also give rise to an anti-competitive probe for conduct that could arise from this violation of these commitments. And these commitments were thoroughly reviewed by CADE's tribunal one by one to make sure that there were safeguards, firewalls, and limitations in place to avoid exchange of competitively sensitive information. I believe that's the main concern that CADE had in that transaction, and that it announced that it would have in other cases involving interaction between competitors for sustainability purposes. They do not want to allow competitors to sit at the table with an excuse that they want to promote a sustainability goal, ESG, or anything like that, and allow them to exchange competitively sensitive information. So lots of firewall safeguards, Steptoe restrictions and controls to these interactions were taken as a commitment voluntarily offered by the parties by CADE. And also another concern that CADE had in that case was the fact that it did not want parties to set standards for sustainability that would be exclusionary of entrants and lower players in the market. In other words, they did not want to allow sustainability to be used as an excuse for you to set such a high standard that would restrain the market to large players that set these goals. And that was also something that was thoroughly reviewed in that case. And CADE concluded that the way that cooperation would work and the self-limitations that the parties voluntarily offered CADE would be sufficient to prevent this kind of exclusionary arrangements by setting standards that could not be met by entrants or smaller firms. And this gave a clear sign as to what we should expect when reviewing future cases of cooperation between competitors for sustainability purposes. Mariana has also mentioned, as you said, the Catena X case, which was ultimately blocked by CADE. In that case, the concern was also with exchange of competitively sensitive information. There were safeguards in place, and CADE thought that they fell short of what is necessary to ensure that no competitive interaction would no exchange of competitively sensitive information would take place. I do believe that that case was an isolated one and does not set a standard or give us a sense of what we may expect in future decisions by CADE, because the reasons for the rejection of the case were very case-specific in relation to a very specific and idiosyncratic point of view from the reporting commissioner at the case. It was ultimately an anonymous decision, but the tribunal has changed. Now we have 4 new members, as Mariana explained, and the tribunal might be sensitive to the fact that Brazil was ultimately excluded from the benefits of that cooperation. But what we just to finish my comments, I believe that what CADE is yet to do, and it may be the next step in relation to ESG and sustainability issues, is to issue a clear guidance, not necessarily through a guideline like they recently did with vertical mergers, but to give better guidelines on what to expect and the limits for cooperation between competitors for sustainability purposes. We do not have these clear guidelines yet, and probably that will be one of the tasks that the new members of CADE's tribunal, along with the 3 remaining ones, will see as a priority for 2024.
Thank you, Marcos. And I think it's fair to say that as anybody, the agency is also subject to type 1 and type 2 errors. So I agree with you that Katina X hopefully will not serve as a reference to future cases. I'll just pause here just to tell everybody that you can make questions. You can either raise your hand or use the Q&A chat box at the bottom of your screen to present us with any questions you may have, and we'll take them at the end of our presentations or throughout the presentation, so depending on the question. But Marcos, I would like to continue with you, and now moving on another subject, hot topic that we have globally, which is the focus on vertical mergers. CADE has just issued guidelines on non-horizontal mergers. Is that the consolidation of CADE's views on that, or is that something new? What are your views on that? You have to unmute, Max.
Sorry. First, I believe that CADE does not have an extensive track record on reviewing vertical mergers. There are a few cases that provide us relevant guidance on how they have done so. But still, they managed to put all that together in the new guidelines that were put on public consultation. One very good aspect was that, differently from previous guidelines, these ones were formally, these ones came as a result of the hiring of an external consultant to draft the guidelines, which is a new process that CADE is starting to adopt more and more. And it's very beneficial because they take external views that put oxygen on what the agency sees from external players, and after that they have a consolidated proposal that is put on public consultation for a reasonable amount of time. This consultation ended on September, and they received several contributions, and they are in the process of reviewing it and about to consolidate in the new guidelines that will be non-binding, as all guidelines from CADE. But the good news is CADE has a very good track record of not departing from the guidelines in its precedents. And when they publish one, they do two things: one that is not so good and one that is really good. The not so good one is that the guidelines tend to just consolidate what is their practice until that point. But a good point of that is that as they don't get into tricky issues or the most debatable ones, they abide to their guidelines. And although it's formally non-binding, they give players in the market a reasonable sense of what to expect from future decisions. And we expect that this will not be different with the guidelines. As to what we have seen from the public consultation, I would make a couple of comments. The first one is that it fails to define exactly what is vertical integration. And that was seen by CAGI after the consultation was initiated. And and officials at CAGI have made public remarks saying that's why we call it a V+. It's not only vertical, it's all kinds of non-horizontal mergers. So mergers that result in portfolio effects, which were not necessarily vertical in the sense that one is supplying the other, are also included in this concept. And we expect that they will make this clear in the final version of the document. They have not also taken a deep dive into portfolio effect to define when portfolio effects may be a subject of antitrust concern or not. And that's something that we don't know if it's going to come in the final version of the document, but has been the subject of lots of contributions in the public consultation. Also network effects, which it's a very clear characteristic of digital markets. It's something that probably will not be addressed, at least not thoroughly, in the final version of the document. And that's not necessarily a bad thing, because it's also something very debatable in the antitrust arena. We don't know how the new composition of CADE's tribunal will deal with that, and we have still some doubts on how to deal with that. But that's something that has not been addressed in the first version. The point that has been very clearly addressed in the public consultation is fast-track eligibility. We used to have a rule that says in vertical mergers, the bar for fast-track is a 30% market share in any of the vertically integrated markets. And that serves most cases, but would bring some problems to cases where the vertical integration was pre-existent, and then you were buying someone that also acts in one of the markets but does not change the competitive dynamics, and just because you have a 30% share, you're not eligible for fast track, although the transaction clearly has no anti-competitive concerns. And the guide now addresses this issue as also, which means that the pre-existence of the vertical integration as something that would allow you to file a vertical merger and the fast track. And the other point that the guidelines address is that when the vertical integration is dedicated only to captive consumption and there's no offer to the market of the product that is involved in this vertical integration, it can be presumably said that it does not change the competitive dynamics of the market, and this would also result in fast track eligibility, even in cases where you might have a share of 30% or more in one of the markets involved. So we still have to see the final version of this document to assess the exact impact that it will have on future review of vertical mergers. But we may expect to have more legal certainty in future cases after the guidelines are issued, probably early 2024. And just this week, the consultant that had been hired by CAGI to draft the guidelines, presented CADE with their assessment on the contributions to the public consultation, and this was a relevant step in the process of making the final wording of the document, when we can expect this to be published soon. In terms of relevant cases, as I said, it's been some time since CADE has reviewed a relevant case of vertical integration, but we have some examples, especially in the health sector, of vertical integration between insurers, health insurers, and hospitals or other providers of medical and health services. CADE has even blocked, as Mariana mentioned in the introduction, a transaction in May this year involving such a vertical integration, and most of the cases involving vertical integration are related to the health sector. So what we can expect for future cases is that CADE will more and more take a tough instance in relation to vertical integration in the health sector, as there's perceived overall there's a notion that is growing among practitioners that we are reaching a point where there's a lot of concentration in the health sector, and this combination of high concentration with a high degree of vertical integration may pose some competitive challenges, and CADE, we can expect CADE to intervene in future cases if they are filed as well. That's it.
Thank you, Marcos. And Mike, I know there are a number of high-profile vertical mergers cases in the US. What Brazil can learn from the US experience?
Well, gee, that's a hard question. And I'll try to answer.
If there's nothing to learn, it's good to know as well, so that we don't cite those cases in our submissions.
Well, what's going on in the States is interesting. Before I get in there, let me take this opportunity to give you the second code word for CLE purposes, and that second code word is vertical. So if you're looking for CLE credit, the second code word is vertical. So I'll get to your question, but the U.S. also has some proposed new merger guidelines that address vertical and conglomerate merger issues. And these merger guidelines are very different from the last sets of merger guidelines that we've had in effect for decades. All of the prior merger guidelines sort of start with the economics and state the agency's views as to what mergers should be permitted and not permitted based on the economic thinking. These merger guidelines, or these proposed merger guidelines, are more of a restatement of Supreme Court precedent of the existing Supreme Court cases on mergers. The Supreme Court in the United States doesn't get a lot of merger cases because it takes years to get to the Supreme Court. There really hasn't been a Supreme Court decision on mergers since the 70s. Some lawyer with too much time on their hands calculated that the average age of the cases that are cited in the proposed merger guidelines is 42.6 years old. But they've withstood the test of time, is what the Department of Justice and Federal Trade Commission will say in response to that criticism. What's interesting is, judges think that their job is interpreting the law and telling you what the Supreme Court precedents mean. We'll see whether these guidelines, if they're if they're adopted in their present form, will be as influential on the judiciary as the prior guidelines have been. So there are three proposed guidelines that address vertical and conglomerate mergers. They're 5, 6, and 7. 5 starts off and tells you that mergers should not substantially lessen competition by creating a firm that controls products or services that its rivals may use to compete. And without using the term vertical, Guideline 5 talks about related products or services, which include inputs, distribution services, things that are complementary, things that give access to competitively sensitive information. And they sort of repeat, the guideline does, traditional vertical merger concerns Can the merged firm limit or degrade rivals' access to a related product, service, or customer? Does that related product or service affect competitiveness? Does the merged firm have the incentive to limit or degrade access? And they'll learn that from prior actions, from the parties' documents. It's pretty much traditional vertical merger concerns. Will the merged firm have access to competitively sensitive information? So that one's pretty typical. The second guideline 6 does use the term vertical, and it says that vertical mergers should not create market structures that foreclose competition. And it tells you that if you have a foreclosure share, which means a share of 50% or more in a related product or service, that alone gives you a prima facie case, a sufficient basis to condemn the merger. If your share of the related product or service is below 50%, then the guidelines tell you they're going to look at whether there's a trend towards vertical integration, what the purpose of the merger is, and whether the merger raises barriers to entry. So again, typical vertical merger concerns. Not a lot new there, I think, in these guidelines. Proposed guideline 7 says mergers should not entrench or extend a dominant position. And this guideline addresses many of the concerns that have been raised with regard to conglomerate mergers. And it asks, is the acquiring firm already dominant? What do they mean by dominant? They mean either having the power to raise price or reduce quality, a typical definition of market dominance, or having at least a 30% market share. That's a really low definition of dominance. So let's look at that one. And then in terms of what the concerns are in terms of for a conglomerate merger, will the proposed transaction entrench or extend a dominant position? Entrenching a dominant position means increasing entry barriers, increasing switching costs, interfering with the use of competitive alternatives, depriving rivals of scale, eliminating a nascent competitive threat, and extending a dominant position means things like leveraging by tying or bundling or otherwise linking sales of two products, excluding rivals, ultimately lessening competition. These are concerns that I used to raise these concerns when I was defending targets of hostile tender offers. Don't see a lot in the recent case law on these issues, but they're there in the merger guidelines because they're there in the old Supreme Court cases. One could ask, gee, why not wait? And if there is tying or bundling or conditioning, prosecute those under the Sherman Act, under statutes that prohibit monopolization or agreements in restrictive trade. And the DOJ and FTC's response to that was, gee, we're looking at stopping anti-competitive conduct in its incipiency. That's the purpose of Section 7 of the Clayton Act. And so that's the back and forth on that. There were, as in Brazil, many comments filed on these proposed guidelines, and the FTC and DOJ need to agree on them. So I'm not expecting that the proposed guidelines will become final anytime in the near future, but presumably sometime in 2024, I'd anticipate before the election, but we'll see. There have been, as Anupam mentioned, lots of vertical cases. I think what can Brazil learn from them? It's sort of a mess at this point, so I'm not sure, other than keep watching litigation and see where things go.
Thank you, Mike. I know we'll move on to another hot topic, which is labor considerations in merger review. And Leo, I'd like to start with you. Well, I think there is a system that stands out globally, which is the one from South Africa, right? Which the law there since the 1998 law says that, actually said because there's a new law now, but that to promote employment was one of the objectives of the antitrust law. And I know that's very unique because of all their history and so on and so forth. But more and more we are seeing that labor considerations are somewhat appearing during the merger review process. How the U.S. authorities deal with that?
Thank you. So I think the U.S. authorities are applying their traditional antitrust principles to labor, but I think that that in and of itself is somewhat of a new development. Certainly in merger cases, labor markets were very rarely considered before this administration. And from an economic standpoint, it's not entirely clear why, because labor markets are an input market, just like any other input. And therefore, just like other input markets were looked at in prior mergers, labor markets could have been looked at as well. But the Biden administration has made looking at labor markets a central part of every merger. They've included labor specs in the second requests. They've included labor information requirements, the new draft HSR rule. And in the draft merger guidelines, there's a new guideline that addresses input markets, but talks extensively about labor markets. And one thing that I find very interesting about those new guidelines is that it walks away from just thinking about labor markets as defined by education levels. Historically, even in conduct cases, when DOJ or FTC looked at labor markets, often they were looking at markets that were defined by some kind of degree or certification. Nurses that had nursing certifications, or engineers that had a very specific degree and had a skill set that was easily differentiated. In the guidelines, as well as in a recent wage information sharing case, the DOJ has looked beyond just education levels in defining labor markets. Instead, looked at other things that make up worker attributes, such as the ability to work long hours, work in difficult conditions, noisy conditions, etc. And I think that really is reflective of the human experience, right? People take jobs for more reasons than just the education level they have. And they may be good at their jobs for reasons that go beyond just the education level they have. And so the merger guidelines, by looking at those characteristics, seek to define markets based on a variety of aspects, not just education. Nonetheless, so far, there have been no merger cases that have really focused on labor markets. And I think the reason for that is that even in defining labor markets narrowly, looking at other attributes besides education levels, trying to find narrow geographic markets, it is very hard to find labor market concentration. To find labor market concentration, you're really going to have to probably find a very specialized skill set in a very isolated geographic market. And there you might be able to find two merging entities that are among the only employers in the area that are the only ones who employ a certain type of person. And there you might have a labor concern. But to even get to the new lower thresholds in the merger guidelines, I think it's going to be very difficult to identify a labor market affected. And that's why I think we haven't seen any labor market cases, merger cases so far.
And what's the situation in Brazil, Marcos? How the CADE has been approaching labor considerations? And I know there is some cases, especially in the financial sector, this has been brought to light.
Yes, it has. I don't think the picture is very different from what Lee described about the US. CADE also sees that his mandate that does not include considerations about keeping jobs and the job market as a whole. It has even said bluntly that the elimination of jobs can be seen as an efficiency in merger cases from strictly an antitrust perspective, although this, of course, all the policies should take care about this issue from a social perspective. CADE has repeatedly said that it's not their job to keep jobs. So the outcome is that we have seen large mergers, as you said, Anna, in the banking sector. especially when Itaú and Bradesco, the two largest private banks in Brazil, bought the Brazilian operation of two foreign banks that were exiting the country. HSBC was bought by Bradesco, and Citibank was bought by Itaú. The unions came to CADE saying this would concentrate even further the market for in the banking sector, and you should take into account job preservation in the review or take it as a commitment. And CADE ultimately rejected those claims. There was also an attempt when Boeing attempted to buy Embraer. Not only the union but also the federal prosecutors came before CADE and appealed a clearance decision issued by the general superintendents. And one of the main underlying reasons of the appeal was the elimination of jobs that could come as a result of Boeing buying Embraer, which was one of the largest Brazilian employers. And CADE ultimately rejected those claims, saying it was not their job to do so. And it does not mean that it has never taken this into account. It has taken this into account when they allowed Ambev, the largest worldwide brewer, to be created by the merger of Brahma and Antarctica in the late 90s. It also took these issues into account when they allowed Gol, Brazilian airline, to buy Webjet. But they ultimately thought that there would not be a relevant change to the job market. So they took into consideration, but to ultimately disregard a competition consent. So CADE has never imposed remedies specifically to address any kind of concentration in the labor market. But attempts for CADE to do so are tried every now and again. And the most recent one that we have seen was a judicial decision by a labor court in the appeals court of Campinas, sitting in the interior of São Paulo, that ordered CADE to take this labor considerations into account when reviewing merger cases. CADE has, in a seldom statement about judicial decisions, strongly criticized the decision, said it would appeal the decision, has appealed the decision, and has not yet formally complied with it, and there's no case which in it has made any reference to the decision when reviewing merger cases. Will CADE comply with it? I believe there's a prior question, which is, will this decision be upheld at superior courts and ultimately the Supreme Court? And that's the most relevant issue here, because if the superior courts ultimately agree with the decision, there could be a shift in CADE's policy, consolidated policy until now. But even if the decision is ultimately upheld, the issue is what CADE can do with it. As Lee said, it's very difficult to assess concentration in labor markets. Is there a specific labor market for each profession, for each sector, and how do you define this? And there's very few case law on how to define the labor market. Is it a single market? How do you segment it and things like that? So the ultimate result might be that CADE will just put a couple of lines in its decision saying that it has not found evidence of a concentration in the labor market that would justify restrictions to transactions, and it would be formally compliant with the decision. That's a possibility. If not, the result would be a very new area of antitrust, a territory that we have not navigated yet. But that's something that will not come before the result of the appeals from this decision from the court in Campinas. We've seen in terms of, and now I departing a little bit of merger specific comments. We've seen some also new concerns from CADE with the labor market by the opening of at least two cases related to exchange of commercially sensitive information in the labor market. There were investigative probes, and CADE is yet to rule on those cases and give guidance on what practices in terms of benchmark and exchange of competitive sensitive information or even no poaches will be accepted under Brazilian law. We have no precedent by CADE on that. And these two cases tend to be the first cases where CADE will give guidance to companies on what they are allowed to do and what they are not allowed to do, especially HR departments, which are the most affected by these decisions.
Thank you so much, Marcos. Now we are moving to our last question of our session today. And I would like to hear, Mariana, from you first on merger notification threshold, which is very, very important to define which transactions get to be reviewed by the agencies. And in Brazil, there's, I think the thresholds are quite broad. We have around, and you will cover this, but we have around 600 transactions every year. We'll compare here apples to bananas, but still it's a fair comparison, I think. The European Commission reviews every year from 350 to 400 transactions every year. I know there are the systems from their member states, but I think it's a fair comparison. So Brazil reviews more transactions than the Commission. Actually, it was even more than that before 2005, because under the old law till 2005, CADE used to interpret the turnover threshold as being global instead of being related to Brazil. So that was super broad. It was roughly $130 million in turnover in the year preceding the transaction on a global basis. So it was quite broad. This changed a little bit under the new law. On the one hand, it's quite broad, but on the other hand, it's not broad enough because we have the data-driven mergers, as Mariana said, as we don't have the value of transaction threshold. There are important transactions that are not mandatorily reviewed by CADE. So Mariana, what is your take on this and how CADE is interpreting the legal thresholds?
Thank you, Ana. Well, just very briefly, and I won't go into detail about our threshold, but as you just said, it's our thresholds are in fact quite broad. We have a pre-merger review system. We have had a pre-merger review system for quite some time now. For quite some time now, over 10 years, and transactions are reportable to CADE if they meet a three-prong test. It's a concentration act. The parties fulfill the merger thresholds, and it has effects in Brazil. For turnover thresholds, we look into, as you said, turnover in the year prior to the transaction by the economic group to which the parties belong. There are specific rules on investment concerning investment funds, and this results virtually in meeting the thresholds for a number of transactions that do not meet the thresholds in other jurisdictions, particularly because with respect to the type of transaction prong of the test, the law requires the filing of transactions such as associative agreements and acquisition of non-controlling minority stakes that are not reportable in other jurisdictions. Just to mention these two examples with respect to associative agreements and minority shareholding acquisitions. To begin with, associative agreements, at least two global partnerships in the pharma sector for developments of new drugs worldwide only required antitrust clearance in Brazil. And with respect to minority shareholdings, a transaction involving a PetroChina investment of a 5% stake in Qatar Energy was reportable in Brazil, even though it was, but it was not reportable in any other jurisdiction. And the issue here was whether it would have potential effects in Brazil because Qatar Energy exports LPG gas globally. So just very broadly, the result of that in practice, translating that into numbers, is that into this year, Kaji had to review 551 transactions so far. It's all of these transactions were reviewed by the general superintendents, but only 11 reached the tribunal. The result of that is that only that most of the cases do not raise competitive concerns. We don't have, Kaji does not publish statistics on how many of these are consist of associative agreements over acquisition of minority shareholding. But based on what we see in our practice, I would say that the number would be close to 50%, 40 to 50% of these. So the point on whether the filing threshold could be reviewed, I think that at least you and I and our pharmaceutical clients and our private investment fund clients would agree that absolutely yes. About merger review, I'll mention one good news that we just heard from the general from Kaji's president is that Kaji's process is mostly electronic, but electronic means today that we basically upload a PDF to their system, and now they will reportedly they will implement a system through which all merger filings will be reviewed electronically, and they will have a screening. There will be a screening process through which fast track cases will be filed and reviewed almost instantaneously. It's unclear how exactly that will happen. Presumably, there will be exceptions to these automatic review system, but it's what we know is that there will be a fully electronic system in place for at least all fast track cases, and that for many transactions, the plan is to have a clearance decision almost automatically. I'll pause here. If we have time, I can elaborate on the rules.
And on that, he said that Kaji will use generative AI, and let's hope that the system will not have many hallucinations. As we're seeing, we were talking about this before, that the system can basically create case law, and I guess they are taking all these safeguards to make sure that this generative AI only have access to Kaji's official system, not to create any case law that does not exist. And Mike, what are the what do we need to know on the notification thresholds and review procedures in the US? Can we also expect the US agencies to adopt generative AI to issue their decisions?
Gee, I hope not until we get rid of the hallucinations. So not much new in the notification thresholds. There's a complicated system that looks at the size of the parties and the size of the transaction, and there's all sorts of exemptions and I would bore your audience to tears if I went into those details. But there are roughly 2,000 to 3,000 Hart-Scott-Rodino notifications filed a year. The good news is they're pretty easy to put together today. With a reasonably responsive client, I can put together a Hart-Scott filing within a week or two. And the bad news is the government doesn't get a lot of helpful information from the Hart-Scott filing, but they get enough information that they know to issue second requests in roughly 2 to 3% of all transactions. So because the government thinks it doesn't get a lot of information that's useful, and probably because the Biden administration is interested in slowing down the merger wave, there are proposed new notification and review procedures that will completely change the system. So right now, it's a very back-end loaded system. You provide very little information up front. If the government thinks they need to issue a second request, they issue the second request, and then you produce an avalanche of information. Tomorrow, under the proposed new regulations, if they are adopted in their current form, it'll be an entirely different system. It'll be much more front-end loaded, much like putting together a Form CO or a long-form notification to CAJE, with really two exceptions. One, there is no fast-track procedure. You have to fill out the whole form in every instance. And two, there's no formalized or traditional system for pre-notification in the US. So you'll have to comply with these far more burdensome requirements without having the ability to as things are currently structured, to discuss with staff in advance as to what information they really need. The slide here lists just by category the kind of information that will be required, but think of it as being a complex, full-scale notification on a Form CO or to CAGE. If these new proposed regulations go into effect, it's going to totally change the U.S. system.
It'll make it more similar to the system we have in Brazil and Europe, right?
Yes, although, as I mentioned, without any ability to talk to staff what they really need, and without any means to fast track or cut down the information that's required. So, yeah, and rather than taking a week or two to put together a notification, think 2 months. It's going to totally change the system.
Yeah.
And and with our low notification thresholds, 2,000 to 3,000 filings a year, it's an enormous shift in costs.
And Mike, when you say 2,000 to 3,000 filings a year, am I right to think that there are separate filings for the opposing parties to the transaction?
Yes.
That's right? Because if you compare to Brazil and the European Commission system, then it's sort of double counting for us, because here we only have a single filing. It could be a joint filing with both buyer and seller presenting the filing, or it could be just the buyer or just the seller. But in any case, we typically only have one filing.
Right.
Yeah, what's a shame about that, or there's many things that's a shame about that new system, but one part of it is that when I was at DOJ, we would get in all these thousands of HSRs, and the first thing that would happen is a manager would look at the parties and just see what they knew about the deal and say, oh, this one there's no problem with, and just push it off to a paralegal who would fill out a document, and that would be the end of it. So now, even for those deals, which were like a whole lot of them, maybe even a majority of them, people are still going to have to incur hundreds of thousands of dollars or more in compliance cost just to put together the filing that no one's ever going to look at.
Yeah.
So it's not going to block the mega mergers from happening, but I wonder whether it'll have a chilling effect on transactions that are smaller, but still subject to HSR review.
Yeah, but then the system can become more automatic, which I think what CAGE is planning to do, having like a more real electronic filing where you put in information sort of following the system we have with our IRS, where you have they fill in automatically some of the responses for you, like past filings and market definition, just getting it out of their own system could help. I don't know. The expectation we have in Brazil is that it will become, first, of course, we have to adapt. But then after we have learned the new system, it's probably going to be less costly than before.
Well, in addition to those kinds of data, what's probably most interesting and also most burdensome will be documents prepared by the companies, not only in connection with the transaction, but in the ordinary course. So the burden, I mean, that's where the interesting stuff comes from when you see the businessmen talking about how the merger will allow you to dominate the industry, and it's really shifting an awful lot onto the parties. But we'll see what happens.
Also, the entire time that I worked for DOJ, we had been talking about getting to a point where we could have electronic submission of HSRs. It still has not happened. It might actually happen soon, but it hasn't happened yet.
Well, nothing gets submitted on paper. They are submitted electronically, but
yeah, right. Yes, sorry, they're not. Yes, it's not submitted on paper, but it's submitted on a disk, right? You're not submitting it.
No, you are submitting it electronically now.
Are you?
Yeah, that was sort of a COVID kind of thing, but yes.
I think we have one question from our audience. Marjorie, I saw that you want to raise a question. With your
Hi Anna. Yes. First of all, I'd like to congratulate you all on this very insightful and informative webinar. I do have a question on non-compete clauses in the U.S. to Michael and Lee. So we are aware that labor-related non-compete clauses have recently come under scrutiny by the FTC, and there's a discussion on a ban to non-compete clauses on workers. My question is how this is expected to affect M&A deals in the U.S. and to what extent non-compete clauses in these deals are also under scrutiny.
So there's a proposed FTC rule that would eliminate non-compete clauses in general. The rule has been under consideration for some time. I really doubt whether the FTC has the power under the Constitution to implement that kind of rule. That strikes me as being a major question, and I would expect a challenge to that rule if it were to be adopted. In terms of how the view on non-competes affects merger analysis, even in the proposed rule, there are exceptions for non-competes, for legitimate non-competes that are reasonable in time and scope in connection with a transaction. So I think that there would still be room under the proposed rule for a typical protection of the buyer or the seller in a non-compete that's reasonably limited to a transaction. But Lee, views?
I agree with all that. The only two things I would add is, first, even though I agree with Michael that the FTC rule is more likely than not going to not be found to be constitutional, there are 5 states already, including very large states like California, that have laws that prohibit non-compete agreements broadly. And so, and those laws are continuing to be considered by state jurisdictions across the country. So even if this FTC rule doesn't come into play, it could still be unlawful under state laws. The other thing is, the exceptions that are in those state laws and in the FTC's proposed rule for transactions certainly apply to those kind of traditional non-competes that you would see that apply to, like, the owner of the selling business, that, you know, the owner won't go and open up a new business that does the same thing for the next 5 years. But in some transactions, there are non-compete clauses that apply to a broader swath of workers, and I don't know that those would be permitted under the state laws or under the FTC's rule.
Thank you, Mike.
Thank you so much.
Are there more questions? Let me just make sure that nobody has their hands raised.
I think Michael had a comment.
Sorry,
I was
Mike.
just going to continue on the non-compete thing. The FTC did bring a couple of recent enforcements of non-competes. One involved a non-compete that prevented a security guard from working for another company. I think of someone with just a very job that doesn't require lots of training, and there's really no reason for a non-compete like that. They don't have access to trade secrets or anything else. And it's just a prohibition on labor mobility and keeping wages down. So that seemed like a legitimate case and a good case to bring. The other case that was brought involved highly skilled engineering type personnel in fiber optics or some glass related industry. Maybe you remember better than I do, Lee.
Yeah, it was glass related industry. And what was interesting about that is that there are so few workers that have the skill to operate the big glass making machinery that it was a way to stop new entrants from entering the market. And there were a number of companies that were complaining to the FTC about the fact that they would enter the market. They have the capital, they have everything they need, but they don't have the workers, and they can't get them because of these non-compete agreements. And so I think it was a really powerful example of how non-competes can not only hurt workers, but also can hurt entry into markets, which in turn had downstream effects.
Well, thank you so much. I think this concludes our event today. Thank you, everybody, for being here. Thank you, Mike. Thank you, Lee, for joining us. So happy holidays to everybody, I guess.
Thank you very much. It was very enjoyable. Thank you.
It was fun.
And thank you all for joining
It was
us
fun.
today. Have a great day.
Thanks.
Thank
You too.
you.
Bye.
Greatly.
Thank you.
Bye-bye.